Good afternoon. This is Marissa with the Texas Association for Home Care and Hospice. Welcome everyone to another exciting webinar by our partners and awesome supporters and advocates from Miles Parker. We really appreciate the work that they do in keeping us educated and how to deal with compliance issues. So today we're doing preventing the revocation of your Texas home health or hospice agency from the Medicare program, tips on avoiding adverse actions. And I don't know if it's longer than that, but that's all I'm going to say. This is a great opportunity for listening in and making sure that you're doing what you can on the compliance side on a proactive way, so that you can keep your certification. Today, our speakers are Ashley Morgan. Ashley is an associate attorney at Miles Parker, Miles Parker's Washington, D.C. office, where she focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ashley particularly is knowledgeable about the regulatory challenges faced by home care providers, especially as they relate to the issues of documentation, and has extensive experience working on administrative appeals of large alleged extrapolated, I can't ever say that word, overpayments assessed by CMS contractors. Ashley also assists providers across the country with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, exclusions, and termination issues. And joining Ashley, or our additional speaker today, is Jennifer Papapanayotu. I don't know if I said that right, but
you did great.
Okay, great. And so Ms. Jennifer practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws, and drafting a wide variety of legal agreements. Jennifer is knowledgeable in all aspects of state licensing for home health and hospice providers, and in the Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. So please welcome Jennifer and Ashley, and you guys take it away. Thank you so much again for this session.
Thanks, Marissa. This is Jennifer Papapanayotu, and Marissa, you did a great job with the name. I know it can be daunting. And I'm a partner here with Miles Parker. Ashley Morgan is joining me, and Ashley and I work together a lot on enrollment and revocation matters. So you guys are getting a double dose today. We probably have at any given time 4, 5, 6 pending enrollment revocation appeals. So we see a lot of this in our day-to-day practice. So if we'll get the slides going, and I'm not seeing the slides on my screen, but Ashley, are you seeing them on your end?
Yes, but we're going to double check to make sure everybody else sees them. See them now?
There it goes. Oh, great. Okay, perfect. So today we're going to cover 3 major areas. We're going to talk about ways you can get revoked from the Medicare program, ways you can lose your Medicare billing privileges. This is separate and apart from things like exclusion or False Claims Act matters or claim appeal matters. This is strictly how you can lose your Medicare billing privileges for administrative reasons. We're then going to talk a little bit about what do those mean in practice, the fastest ways to get to one of these revocation reasons, and give you some useful information about how to avoid a revocation based on these various different reasons. And then we're going to cover at the end, how do you manage if a revocation does happen. So we'll talk about caps, and we'll talk about reconsideration, and we'll talk about the appeal process in overall. So let's go to the revocation reasons themselves. And Ashley, why don't you kick us off here?
Great, thanks, Jennifer. So there's 14 different bases under the regulations for why you could be revoked from the Medicare program. It essentially gives CMS the authority to revoke you if one of these 14 issues is present. We've bolded some of the ones that we see more often, but that doesn't mean that we haven't seen the ones that aren't in bold as well. We just see the ones in bold more often. The first one is that you're not in compliance with the Medicare requirements. So that means if there's something in the enrollment application or the regulations that you are required to have or to have, disclosed to CMS upon enrolling, and they discover that, you don't actually meet those requirements, then they can revoke you for failure to comply with those requirements. You can also be revoked if you or any of your providers, any of your owners, managing employees, authorized or delegated officials, medical directors, supervising physicians, or any other healthcare personnel are excluded or debarred from the federal program. We'll talk a little bit more later on about what that means, but essentially Medicare has made an official final determination that you are not eligible to participate or to provide services to Medicare beneficiaries, and so based on that exclusion, they're going to revoke your billing privileges. And if you have I know that you all are agencies, so if one of your managing employees or one of your owners is excluded, they can revoke your entire agency based on that. If there's a felony conviction, any felony conviction in the last 10 years, CMS has a lot of authority on this one to just kind of determine whether or not they think that a felony conviction is detrimental to the Medicare program or any of its beneficiaries. But if they determine that a felony conviction exists that is detrimental to the program, they can revoke your billing privileges based on that. If they determine that you have provided false or misleading information on one of your enrollment applications, they can revoke you as well, and they can also impose fines or imprisonment for that in addition to just revoking your number. The intent for providing that information, it doesn't matter, it's irrelevant. And it's also important to note that if you fail to disclose information, so omitting information on your application, that's also considered to be false or misleading. So it's not just providing incorrect and improper information, it's also not disclosing pertinent information. For example, if you had an adverse action and you failed to put that on your enrollment application. Another big one we see is on-site review or other reliable evidence requirements that are not met. The most common we see here is failed site visits. That's usually listed in conjunction with not in compliance with the Medicare requirements. Essentially, somebody from CMS is going to come to your office and see, conduct a visit, make sure you're in operation like you say you are at your posted hours. And if you've moved and haven't given them your updated address, or if you're simply not open, then you could be revoked for that reason. A hardship exception, denial, and fees not paid, that's another one that you could be revoked for. Misuse of a billing number, that would be if you have a provider that's not credentialed and you're knowingly letting that provider use your number and billing under your number, you could be revoked for that. And go to the next page. Abuse of billing privileges, this is a big one. Most commonly, this was previously for billing for deceased beneficiaries, which you are permitted to do a couple times, but once you do it a third time, you can be revoked for that. So believe it or not, that does happen. That's actually in the Federal Register that it's okay for it to occur 2 times, but on the third time, they can revoke you. But they've also, this regulation changed in 2015, and now in addition to the impossible services meaning, couldn't have actually provided services to someone who was dead on the date of service that they were dead. They've also added a pattern or practice of billing errors, and we're going to get into that one as well later on, but there's a certain set of criteria for what they consider to be a pattern or practice of billing errors, and we've seen a lot of these types of revocations. Another one is failure to report changes. This is another option to revoke if a provider or supplier fails to report an adverse action or change in location. There's a couple different things they could choose, and sometimes they'll choose more than one basis to revoke you. So you have an obligation to report certain changes to CMS within a certain amount of time. For example, there is an adverse action, it needs to be reported within a certain number of days. If you have a change in site location, that needs to be reported within a certain number of days. Suspension of a license needs to be reported, and failure to do so can result in a revocation. Non-compliance with documentation requirements, meaning if you, for a home health agency, if you've got written orders and certifications for payments for home health services from physicians, if you're not complying with those requirements to have those orders and certifications, and CMS identifies that probably through an audit, they could revoke you for that. They could also revoke your agency for capitalization purposes, meaning if CMS requests proof of your initial reserve operating funds, you have 30 days to respond to that, and if you fail to demonstrate that you have that proper funding available to you, then they could revoke you based on that. If your Medicaid billing privileges are revoked, then they could also revoke your Medicare number. Individual providers could be revoked for not having DEA certificates, or if your state prescribing authority is suspended or revoked, then your physicians could be revoked because of that. And another one is improper prescribing practices, meaning if they identified that a physician, again, had been improperly prescribing drugs to patients, then the physician could be revoked. So we have taken these 14 revocation reasons and we've grouped them into the 4 most common ways that you're going to lose your Medicare number. So we're going to talk about a couple of them in each of these different 4 ways. The first one we're going to cover is enrollment problems. So that's going to be a failure to report a change of location, a failure to revalidate your number on time, failure to report adverse legal actions, things that you could do, you personally failed to do and now you've been revoked. Operational problems, that's going to be, a failure to keep your business hours, a lack of proper signage. If you're not reviewing your employees to make sure they're not excluded and you have an excluded person, that's an operational problem you could be revoked for. Then we're going to talk about billing problems, for example, the deceased beneficiaries issue I just mentioned, or failing to self-audit or haphazard billing. And then we're going to close out with a discussion of documentation problems, a failure to keep required paperwork to support payment for services. And then we're going to go to the next slide, and Jennifer is going to start us off to talk about enrollment problems.
Right. So of the 4 categories that we're going to cover, I would say categories 1 and 2 are probably where we see the most activity by the contractors and CMS in revoking providers. So enrollment problems, I lumped in here anything and everything that has to do with maintaining your enrollment record. So it can be making sure your addresses are correct, making sure your ownership information is correct, making sure you revalidate in a timely way, reporting adverse legal actions if it's relevant, anything and everything that has to do with keeping that record up to date. So if we'll go to the next slide. So generally these fall under revocation reason 5 or revocation reason 1, and those 2 often go hand in hand. So 5 generally is focused on, they've tried to do an on-site review and for some reason they can't find you. Or they located you, but you were closed during hours when you're supposed to be open. The way the site visits work, if the listeners are unfamiliar with that, there's a contractor that's a national site visit contractor that is been authorized by CMS to go out and do these site visits. They are to a large extent random, although I will say that they seem to cover certain geographic areas at certain times. So you may see them do a specific county all at one time, and I'll see a spate of revocations from that particular area. But it's random, it's unannounced, you don't know what's happening, and oftentimes, people will get these notices or they'll just notice something's wrong with their claims payment, and they're like, well, what happened? They contact the contractor, they talk to Palmetto, and Palmetto says, oh, you were revoked. And oftentimes it's a surprise to the provider because this isn't one of those kinds of site visits where they're going to walk in and review records or anything like that. It's strictly an external review, and they're looking for the lights are on, somebody's rendering, if somebody is present at the business during its regular business hours. Generally, the site visit contractors make more than one visit. If they don't find the lights on and no one's home the first time they come, then they'll come at a different time of day during the posted hours a day or two later and try to, give you another shot at it. If they visit twice and they cannot find anybody at home, they are technically able to walk away at that point and report you as not operational, and process a recommendation for revocation. Oftentimes, these site visit contractors will try to make phone calls to the agency. They may leave messages. They may reach out. So I tell people it's really important, A, that your hours of operation are posted as they're supposed to be, that you've got good signage on your agency, that I actually had a case once where someone was revoked because there was a mistake in the building directory, and the site inspector, rather than just going to the suite number that was on the enrollment record, looked at the building directory and went to the wrong place. Ultimately we were able to resolve those situations, but site visits are probably the number one reason why I see home health and hospice agencies revoked. And it's an unfortunate scenario because it's strictly it's a record-keeping problem. It has nothing to do usually with how well you run your agency or how well you take care of patients. It has everything to do with just administrative record-keeping problems. So if they can't find you, or they find you but the lights are not on, then you can be revoked for this on-site review reason, and it often ties into they'll list more than one reason, and they'll say you were non-compliant with Medicare regulations, and generally that means that you were not operational during your regular posted hours. So how do you keep this from happening? Well, you keep your enrollment record current. You send in the right applications or report through PACOS. And to avoid problems, should anybody ever question whether you did an update, my advice to folks is always keep copies of absolutely everything you submit, whether that's a paper application or it is a PACOS submission. When you work with PACOS, there is a way to capture and print out if you submit a change of information, for example, to print out what you're submitting. You can do that. There's a way to do it through the PACOS system. You'd be shocked how many people never print out what they had submitted through PACOS. It becomes a problem because later on, if something happens and that submission, for some reason, there's a technical problem with it, you will have no way of proving what you actually input and that it went into the system if you don't have something saved about what you put in. I actually had a woman up in another state, not in Texas, who had this problem. She understood from her process through the PACOS system that she had submitted it. She actually called the contractor and said, "Can you see it on your end?" And they said yes. And something happened in the technical communication within the PACOS system, and that particular update fell through the cracks somehow. And it was a very unfortunate scenario, and she had nothing printed out about what she had submitted through PACOS. So a long process sort of ensues from there. But my advice to everyone is, even if all you do is print a paper copy of what you're submitting in through PACOS, if you create a PDF of it, that will be very helpful. If you're mailing applications and you're using the paper 855A to do updates, always keep a copy of the signed application. Use a form of trackable mail, whether that's FedEx or UPS or priority mail, certified mail, something that shows that you can track delivery and prove it arrived at Palmetto. They lose stuff all the time. It used to be, before PACOS was more prevalent, was used more by most providers, that most applications were submitted on paper. And Palmetto has a centralized mailroom where everything comes in, it's all logged in, and it's scanned. And you can imagine they get thousands of pieces of paper every single day, and things do get lost. So it's really important, for purposes of defending yourself, if you're ever revoked, that you've got copies of everything you submitted with the signatures on it, if you do it on paper, and that you can prove that envelope was actually delivered to Palmetto. So let's go to the next slide. So what do you have to report? What do the regulations require you to report? Well, there's a laundry list. virtually any field on an 855A application or in PACOS that changes is something that you have to report to them, that you've got a certain amount of time to tell them there's been some change and I'm reporting it to you. Obviously, the enrollment regulations, I've given you the regulatory citation, but these are sort of our tips and tricks that we share with folks. So always use the right application. You'd be surprised. People will fill out the wrong application. They'll send an 855B instead of an A, or that's not as common when you're talking to home health and hospice, but individual providers and Part B providers tend to make these mistakes more commonly. Always fill out the application truthfully and completely. Leaving things off can be as big a problem as putting things on that you think may be problematic. And if you have questions about whether a particular piece of information is going to have a negative effect, by all means, pick up the phone, call your health lawyer, call someone who's knowledgeable about the enrollment process, and they can help you through that. So you can plan for it if you're concerned that there's going to be some negative effect of you reporting a piece of information. When an authorized representative of the entity signs an enrollment application or signs a certification page for PACOS, they're attesting that the information is accurate and that the provider or supplier is aware of and abides by all applicable statutes, regulations, and program instructions. So it's really important, A, that the authorized rep has reviewed the application, that they know what they're signing and they know what's being disclosed. Be sure you send in all attachments or upload all required attachments to PACOS. Sometimes missing pieces of information get lost from the record or don't get submitted on time. And if you are in the process of doing a change of information, let's say you're updating an address or something, and they come back to you and ask for information to support that change of information with a development request, if you fail to respond to that development request, they'll throw the application out. And sometimes folks don't realize these things have fallen through the cracks, and over time, that record didn't get updated, and for whatever reason, a site visit, say, happened, and that address didn't get updated because somebody didn't close the loop or provide a piece of information that was requested, and then they're surprised, 6 months or 12 months or 18 months later when a revocation happens. It's really important to track an application all the way through the system to completion. Make sure you get that approval email from PACOS, that approval letter from Palmetto. All providers have to participate in EFT. I don't think I need to talk about that in too much detail. I've mentioned that the authorized representative that signs an application or a certification page is someone who has the authority to bind the provider or supplier. A biller generally cannot sign for an entity. An administrator, unless they're an owner or appointed executive, is not supposed to be signing for the entity. Many times with our clients, the administrator of the agency isn't considered an executive and has been appointed as an executive by the ownership. So you just be aware of that. Authorized reps have to meet certain requirements, and they're described and explained in the application itself, actually. If a biller or outside credentialing person is helping with applications, and this is extremely common, my advice to providers is that you never give a third party, someone who's not you, the right to submit something on your behalf. They can fill out the paperwork, but it's your job as the person who signs off on that application to review it and make sure it's correct. And you should never let someone sign your name for you. That's a big no-no in the enrollment world. You, as the authorized rep, are making representations to the government about what's in that application, so you should know what's in it, and it should be your signature on the application. So let's skip to the next slide, please. So there are certain categories of providers that are subject to site visits. Site visits are really important for both initial applications, and I'm going to throw a little party right here and say, yay, they've lifted the moratorium on new home health agencies in Texas. So while I haven't received a whole lot of phone calls about folks trying to open new agencies, I suspect we're going to see that happening as people get through the accreditation process, and we'll see a lot more new initial applications. So site visits are required and will be happening on a random basis, but they are required if you're in the moderate or high screening category in some specific situations. So hospices, when they're initially enroll and when they revalidate, are subject to this moderate screening category, meaning they have to have a site visit, and revalidating home health agencies also have to have a site visit. High screening category providers are new home health agencies, and there are other provider types that fall into these categories, but a new home health agency also has to have a site visit. Why is that important? How does that tie back into revocation? Well, when you revalidate, they're going to do a site visit. And because of that, you better be sure your addresses are right and that the office is being manned during regular business hours all the time. If you have to leave for some reason and you're the only person in the office, put that, we'll be right back in X number of minutes, and this is who you call if you have a question. Generally, that's enough to let a site visitor or a site inspector know, hey, you're going to be back. It's not abandoned, and they'll make a second visit. But it's really, really important for any home health or hospice operator to understand that your agency has to be accessible, meaning they have to be able to get to the agency, and it has to be open and operational during regular business hours. If you fail a site visit and you're an initial applicant for certification, they're going to kick the application out. You're going to have to start over with the 855. If you fail a site visit on a revalidation, they're going to deactivate your agency because they're going to say the revalidation was unsuccessful. Those can be fixed, but it can be costly and can take a lot of time to get your privileges turned back on. So it's important that you're prepared to pass a site visit the very first time an inspector comes by your location. There are fingerprint-based background requirements now for high-risk screening category providers like new home health agencies. I'm not going to go deeply into that. There is a contractor for it. We have dealt with some scenarios where people fail to submit fingerprints when they were requested and they've lost their billing privileges. But just be aware, if you're a new applicant for a home health agency certification, that these fingerprint requests will apply to you. So let's go to the next page. I made a little chart here. You might want to print this out when you download the PDF of the slides. These are your reporting deadlines and your reporting requirements for changes to any information on your application. And you can see some of them are 30 days and some of them are 90 days. And this is within 30 days after something like this happens. So changes of ownership, changes of control, which are generally shareholder and member changes, and changes of authorized or delegated representative. Those all have to be reported within 30 days after they happen. Final adverse legal actions, changes of practice location, and all other changes to any other section of the 855 have to be reported within 90 days. So that's a handy chart to keep in front of you, so you know when and how you're going to have to report things. Revalidation, round two has been in full swing for a while now. I've provided you some resources here. If you have not yet been requested to revalidate, you can go to the data.cms.gov revalidation website that I've listed here and put in your identifying information. And if you're due for revalidation sometime in the next 6 months, it will pop up there and it will tell you what the due date is. If you show up on that list, my suggestion is go ahead and revalidate. You can do it early. If you have not submitted a revalidation within 2 months of your due date, you'll get a letter or an email saying that your revalidation is due and giving you the due date. It's really, really important for purposes of revalidation that your addresses in your enrollment record are current, both your mailing address and your email address. If they can't find you to give you that revalidation notice, you won't know about it. You'll miss the deadline. So log into Pecos, make sure those addresses are accurate, and if they're not, update them. The other way, obviously, is you can find whether or not you're on this list. It looks forward 6 months. It also gives historic information about when you were last asked to revalidate. So it can be really helpful for helping you predict when you're going to have to do this and kind of get ahead of the game. You can use a Pecos or a paper application to do revalidation. Keep in mind that there is a fee payable to Medicare for revalidation. If you don't pay the fee, they'll kick the application out, and it actually can serve as a ground for them to deny the application and take away your billing privileges. So it's important. I've given you the website where you go and pay the fee. You're supposed to send that proof of payment with the application if you send a paper app. If you do it through Pecos, I don't remember specifically if you upload that or if there's a link within the Pecos application. I apologize. I don't use Pecos as much as providers who do this a lot, but there are instructions when you're in Pecos about how to pay the fee and what you need to provide. Keep in mind, if you miss a revalidation deadline for some reason, it is not the end of the world, but you cannot ignore that either. Ashley and I have worked on a number of cases where people have submitted late revalidations, and depending on how late it is, oftentimes they will reactivate your billing privileges, generally effective the date you delivered the revalidation application. If it's within about 30 to 40 days after the due date, generally they will backdate your revalidation to the date it was due. If they don't, I highly recommend you contact your health lawyer and ask for help appealing that effective date. Ashley and I have had great success working with CMS to get those effective dates improved, I'll say. Sometimes we're able to wipe out a gap completely. Sometimes we're able to just reduce the gap depending on how long it is. I mean, I had a provider with a 7-day gap. We made it completely go away. I've had providers with a 2-month gap where we've been able to cut it in half. I've had a provider with a 5-month gap where we were able to cut it in half. And it's important because you're going to lose all those claims during that gap period. And to the extent we can make it go away, or at least reduce it as much as possible through the appeal process, obviously that's a great advantage to you. So let's go ahead and go to the next slide. All right, traps for the unwary. These are the things that can go wrong. Okay. Anybody who's logged into Pecos and tried to use it, maybe you're more tech savvy than I am, but I find that particular system to be complicated. I find it to be, it's not intuitive. Again, my recommendation to you is take what little training they offer for Pecos, watch the videos about how to do things. It's a menu-driven system. Sometimes there are additional instructions they'll provide as you're going through these menu systems to answer questions. Read those instructions carefully. Once you've got an application ready to go, there is a way to print it. I would highly recommend you print what you're submitting and keep a copy of it. It's amazing to me. Ashley and I have worked on many, many revocations where Pecos was part of an application process, and there has been some problem with what was submitted or what the provider thought they submitted and what the contractor actually saw on their end. So again, keep copies, keep copies, keep copies. If you send something to a contractor, send it by trackable mail, print the proof of delivery. It's the only way you're ever going to win an argument that you did submit a change where Palmetto says they never got it. You have to prove delivery, not that you sent it. I think my last tip is if you miss a deadline or you're late reporting something, that doesn't mean you shouldn't do it. You should do it, and you should do it right away. And if you're concerned about the effect it might have, contact your healthcare counsel. All right, let's go to the next slide. Ashley, I think you're going to pick up on operational problems.
Yep. So we're going to get into operational problems. So we can go ahead and go to the next slide. The two that we're going to discuss are reason number 5 and reason number 2. In our first, when we first discussed all 14, these are the reason numbers. Reason number 5 is an on-site review or other reliable evidence that requirements are not met. So that would be similar to what Jennifer was just discussing, poor or no signage or failure to keep regular business hours. So as Jennifer said, at your agency, if you have your business and you're still at the address of record, you need to be open when you say that you're open. So as Jennifer said, if somebody needs to step out for something in an emergency and you're the only one there, then you need to make sure that you put a sign on there, we'll be right back in a certain number of minutes with the phone number where you can be reached so that that site visitor can call you, because if they try to come and they try to come more than once and you're not open, then they're going to revoke you for that. They consider it the same thing as having changed addresses as not providing them your right address. So you need to make sure you have a sign that says this is our agency, this is where we're located, and that you're actually open when you are open. Number 2 is excluded or debarred from the federal program. So if any of your providers, owners, managing employees, authorized or delegated officials, medical directors, supervising physicians, or any other healthcare personnel are excluded or debarred from the Medicaid program, those people are not eligible to render items or services to any Medicare beneficiaries. So if they are excluded, then your agency can be excluded because of that purpose. So you need to make sure that you are doing an exclusion check every month to make sure that none of your owners or employees or managing employees are excluded. So we're going to go ahead and go to the next slide. So for reason 5 revocations, how to prevent revocations based on this. State licensing and Medicare regulations require that most Part A providers do have proper signage and post your hours of operation and emergency contact numbers. So by your state requirements and because of Medicare, you need to make sure, like I said, you have your name on the front of your agency and you have posted hours and that you're actually open during those hours. You should be treating your office like it is a retail business. You need to be open to receive patients and surveyors during your regular hours. I know that, home health agency and hospice agencies, you're not treating patients at the agency, you're treating them in their home. However, you still have to have your business location open during certain operating hours. And you just have to consider yourself like a physician's office, like you're going to be there open to see patients, because they wouldn't close down a local hospital so everybody can go grab lunch. You need to make sure that somebody's always there to answer the phone and to answer and let contractors and surveyors come in the event that they do decide to show up for a site visit, because you're probably not going to get advance notice that they're coming for a site visit. Make sure you're planning for emergencies. If you have a regular receptionist that does man the office and they're sick, who's going to cover? Make sure you have coverage for lunch. If that receptionist gets an hour lunch break, then make sure there's somebody that can cover the desk during that hour lunch break. You also need to make sure that for the emergency contact number that you list along with your posted hours, that someone actually reviews those messages and answers the phone when it rings, so that if somebody does try to call, you can say, oh, we'll be right there. We just had to step out for just a second for an emergency, but we can come and let you in. So you need to make sure that that number's posted and that you're actually answering the phone and responding to any messages. For reason number 2, revocations, for exclusions and debarments. We recommend that you need a standardized hiring process for hiring all of your employees, all of your managing employees, anybody that's going to be involved with the company. You need to have some sort of standardized practice where you're checking their licenses and that you're checking that they're not excluded. They are separate things. An exclusion is essentially, there has been some sort of final administrative action taken against an individual. It could be based on a misdemeanor or a felony conviction. It could be, failure to repay student loans. It could be a licensure issue. There's a wide variety of issues for why someone could be excluded, but it's a separate check. You don't just check on the state licensing board. There are 2 federal lists, and I believe there's 38 or 39 individual state lists that need to be checked. Medicare and Medicaid, most Medicaid states do now require monthly exclusion screening of all of the lists. If you're excluded on one state list, then you're excluded under all state lists, even though you might not appear on all the state lists. And it's important to know that a lot of times the states, even though they should be reporting information to the federal government that they've excluded somebody under their Medicaid program, that doesn't always get communicated in a timely fashion. So that's why it's important that you are not just reviewing the OIG-LEIE and GSA, which are the 2 federal lists, that you're also looking at all of those state lists as well to make sure that you're not missing an exclusion anywhere. Because the problem is that if you have been found to have hired one of these people and have them on your payroll and they're providing services, they were never allowed to see any of those providers. So it's a large issue, but the main issue here is that if CMS discovers that they were excluded, they can actually revoke the agency for that. And CMS maintains that it's your obligation to check monthly to make sure that none of those people are excluded. And if they are excluded, if you find out that somebody is excluded, we do recommend that you take swift action to address it. that you're consulting with your legal counsel to go through possibly the OIG self-disclosure protocol and resolving that issue with them.
So Ashley and I actually handled a scenario like this recently for a provider where a medical person, a physician that had been working with the business, they discovered much after the fact that he had been excluded. And actually he'd been excluded. Well, he had been a part owner of this business, and it wasn't a home health or hospice agency. It was a different kind of provider entity. But he'd been excluded, but had divested his ownership interest. But for reasons that were specific to the provider, apparently he still appeared on the ownership record, even though it was a very small percentage. So the contractor discovered that this person still appeared as a minority owner. It was a very small ownership percentage. He was still on the record, but he also popped up on the exclusion screening list. And they sent a revocation to the business. And there is a way to cure a revocation based on the exclusion of an owner or managing employee. Basically, if you divest an ownership interest or you terminate that managing employee within a very short period of time after the revocation happens, then you can actually cure the revocation and make it go away. So it's A, important that you avoid this ever happening, but B, if it does happen, that you take very quick action, because I think the period's 30 days after notice of revocation, or notice, it's written into the sub-regulatory guidance for revocation based on this reason. You have 30 days to take action to fix it and to provide proof that you've done it. And we're actually right now awaiting a decision at the first level of appeal for this particular client, because we were able to provide that evidence that this excluded person was no longer part of the organization. And we expect that's going to be favorable, but you've got to go through the process, and you don't get the usual 60-day period to file an appeal of a revocation action. We'll talk about that a little later on. You really only have this 30-day window. So exclusion is actually becoming a bigger and bigger problem, because the exclusion reasons that exist, what we call the permissive exclusion reasons, loop in so many different things, and there are so many exclusion lists that you have to keep your eye on, that a lot of folks who have a fair number of staff have taken to using outside services to help them do this exclusion screening, and there are a number of them out there. It can be quite affordable to do it that way, and they can actually do the screening for you on a monthly basis and check all of the available exclusion lists, so that it takes some of the sort of administrative burden off agency ownership and management to do that for them. So that's the end of my spiel.
Yeah, absolutely. It is really important that, if you get a revocation based on this reason, that you take immediate action. Don't let it sit around for, 28 days and then decide to do something. You need to take immediate action when you get any of these letters, frankly. All right, let's go to the next slide. So now we're going to talk about billing problems, billing for deceased beneficiaries, or a pattern of practice with billing. We can go to the next slide. We've recently seen an uptick in the use of this specific revocation reason for getting providers out of the program by CMS and its contractors. This specific revocation reason was actually expanded in 2015. It used to just cover what we call impossible claims, which, for example, is billing for a deceased beneficiary. I know that sounds crazy, but it does happen. If you made a mistake on your claim form, you messed up the date, and it just so happens that the beneficiary passed away, and that clearly you couldn't have provided the services when the beneficiary was dead. However, but in 2016, they expanded the regulation, and now CMS has a pretty significant amount of discretion to determine if there is a pattern or practice of billing errors. And there are certain factors that they consider. They're on the screen here for you. They include the percentage of the submitted claims that were denied, the reason for the denials, if there's any history of final adverse action for the provider, the length of time over which they could think this pattern has continued, how long the provider or supplier has been enrolled in Medicare, and then, of course, a catch-all for any other information that they deem pertinent to whether or not there was a pattern or practice of billing errors. This specific revocation reason is really data-driven. It's driven by those post-payment and prepayment audits that ZPICs and UPICs are conducting of the agencies. If they see that you have a really high error rate and that's continued over a long period of time, CMS can come in and and that doesn't necessarily have to be over a long period of time, I shouldn't say that. If they see that you have a high error rate, they can come in and revoke you based on that. And to survive this revocation, you're likely going to have to not just deal with appealing the revocation. There may also be a claim appeal depending on the date that they've decided to revoke you. They can decide to revoke you earlier in time. And for example, if you are a provider, this is a recent example that we have, that was suspended and you submitted claims during the suspension because you didn't realize that you were suspended. They could revoke you for failure to report the suspension issue, and they could revoke you for abusive billing privileges. And they would revoke you retroactive to the date that you were no longer properly licensed. And they would say that during that period of time when you were still rendering services, none of those qualified for coverage and payment, so you need to repay all of that money, and then you're also revoked. So you have a claim appeal for all of the claims that were rendered during that period of time, which is its own separate appeals process through the claim appeals process that we all know well, and then the separate revocation appeals process that we're going to discuss. There are no ways to stay provider enrollment revocations, so you're just going to have to fight both of those appeals while you are out of business, unfortunately. And like I said, we've seen an uptick in this specific revocation reason. We've particularly seen, which I think is very interesting, that CMS is using the rules, not the rule, the guidance from the Federal Register that you can submit up to 3 impossible claims before you are revoked. They're now applying that to the pattern or practice of billing errors by saying that they consider there to be a pattern or practice of billing errors if you've submitted 3 or more claims that they consider to be improper. So that's really a really big question, and we don't quite have an answer to it yet because CMS has not spoken to it. We've looked at the rules. There haven't been a lot of decisions from ALJs about the specific new pattern or practice of billing errors revocation reason. They've only really discussed the impossible claims issue, and now that CMS is using this impossible claims basis in the Federal Register for the pattern or practice, there hasn't been a final decision yet from an ALJ on whether or not that's proper. In my opinion, I do not think that's proper because they've got all of these other reasons, like the percentage of the claims, the reason for the claim denials, and the length of time over which the period has occurred. So why would you have a percentage in addition to a specific number? But it is important to note that they will and have been trying to utilize very small amounts of claim denials for revocations based on this reason. And Jennifer and I have seen a variety of audits where there's only been maybe 8 or so claims that they're considering to be a pattern or practice of billing errors.
Right. We've actually got 2 cases pending right now where this is an issue, that the provider was revoked for this abusive billing privilege reason, and there are different fact patterns actually with each of them. One was a history of audit problems, and the other was a licensure suspension issue. But in the reconsideration decisions that came out after we went through the first level of appeal, in both instances, they're relying on the pattern or practice of billing errors, which has these specific criteria that CMS is supposed to consider. And the reconsideration hearing officer, who is not a CMS person sometimes it is, sometimes it isn't. It depends on where the appeal's filed. But they're coming back and saying, oh, 3 claim errors, that's a pattern or practice. We're going to, sustain the revocation. And So Ashley and I are actually in the process right now. We've appealed 2 cases to the administrative law judge level, and we're just at the beginning of those cases, so it remains to be seen how they're going to play out. I think our arguments are excellent. Ashley wrote an awesome brief on this issue, and we'll hopefully publish an article or something once we see how this plays out in practice. But I can't imagine CMS is going to be able to sustain an argument that 3 errors is a pattern or practice, especially with these criteria that they are supposed to be considering. So I think those are probably outliers. I sincerely hope they're not going to be able to do that. I mean, 3 claims for a business that may file hundreds and hundreds and hundreds of claims a year is certainly not what I would consider a high percentage of claims that were in error. And the impossible claim reason was always intended to address things that looked a lot worse, right? That you billed for somebody who was dead, which can be an innocent error, but also can be an indicator of fraud. And also the impossible claims included things like services that had to have been provided in person, but the person who billed the claim wasn't physically able to even have been in that location at that time. So those are supposed to really involve the 3 error thing was supposed to involve facts that were a lot different. The other way we see this pattern or practice of billing error used is in suspension revocation cases where a provider is suspended for a credible allegation of fraud, which is usually based on just 5 claims, and then they'll follow on right behind that with a revocation. When we see those happen, that's almost always the indication of a larger investigation that's going on into the provider's conduct. It is not just a simple claim audit. And so with that, Ashley, I'll turn it back over to you.
Yeah, thank you. And something else we've seen too, specifically for home health and hospice agencies, is under this revocation reason is that you're being revoked when a physician is then coming in and telling a contractor that they never referred or acted as an attending physician for an agency. I've actually seen quite a few of those cases before, but if the physician does that, then they're going to revoke the agency for abusive billing privileges because, therefore you didn't have the proper certifications or orders that you needed to provide those services, so they think you were committing fraud if the physician says that. So we do see quite a bit of that for home health agencies and hospices. So next slide. So how to prevent this specific revocation reason? We highly, highly recommend that if you don't have a compliance plan in place and if you aren't doing periodic self-audits of your claims, then you need to start doing that as soon as possible. Doing those internal claims reviews can really save you a lot of headaches. You can identify things that might not meet the coverage requirements, so you're in a better place if you have an audit, and you can see if there's errors in your practices of billing that you can then fix. It's much better to identify an error independently and fix it yourself, even if that may involve making a voluntary refund to the program and repaying certain claims. You're saving yourself a huge headache later on down the road because, as we all know, the government is really good at collecting data about us and about the companies that work with the government. So they've got a ton of data, and they regularly are reviewing that data, hiring contractors who their specific job is to review that data. So they're going to, if there is an error that they're going to identify that as an aberrance in their system, and they're going to investigate it. So it's much better for you to find it first and fix it. That way, when they come in, you can say, oh yeah, we did identify that through our regular compliance practices, and we then refunded that money to the program before you ever even came in and said anything about it. Make sure you have a compliance program that's actually suitable to your practice. You don't just want to download one off the internet that doesn't necessarily have everything that you need, and make sure that your denial reasons and work to reduce their frequency. And I just saw the time, so I want to go ahead and go to the next slide. I think, Jennifer, you're going to talk about documentation problems.
Yeah, we'll briefly touch on documentation problems. This typically pops up when you get a request for documentation and for whatever reason can't respond to it fully. You've got missing signatures, missing orders, missing certifications, and I know in the home health and hospice issue, this is an ongoing challenge for providers to make sure they have all the right pieces of paper and that they're all signed timely, and that when you get a request for this information, you're able to produce it. So I don't see as many revocations under this reason as I used to, because I think everybody's just sort of been beaten over the head with it for so long. This has become less of an issue, and frankly, they've weeded out so many of the sort of marginal providers, for lack of a better description, or people who were not able to implement robust systems to make sure that their documentation was complete, that this is becoming less prevalent. Let's go to the next page. So I want to be sure we spend at least a few minutes talking about what do you do if the worst happens. And the first thing I'll tell you is, if you don't have healthcare counsel, make a phone call, find someone. You can contact TAC. They can give you some names and referrals. Obviously, our firm provides these kinds of services, and there are other law firms out there in the Texas market that do this kind of work. Depending on the revocation reason, your effective date may be before you got the letter. That's especially true if it's based on a site visit. You'll be revoked as of the date of the last attempted site visit. For most other reasons, if they're based on billing errors or documentation, it'll be 30 days from the date of the revocation letter. As Ashley said before, once a revocation is in place, it stays in place while you're appealing it. So you do not have the luxury of being able to keep billing. You're going to be revoked the entire time you're trying to appeal something like this. So it's important to jump on this as quickly as possible, get counsel involved, and start filing your appeals. It is likely, if Medicare revokes you, that Medicaid will as well if you're enrolled in Medicaid. That can take a lot of time, but you should know you probably have reporting obligations to Medicaid if you're revoked by Medicare. And you probably have reporting obligations to private payers as well under your contracts with them. If you're accredited, you have to report it to your accrediting body. So there are a lot of things that have to happen if a revocation happens, and having someone who's been through this process and understands how it works, a competent healthcare lawyer can really help you navigate it quickly and try to minimize the damage. So let's go to the next slide. I kind of covered a number of these points already. Immediately call your healthcare counsel. Ashley and I get a lot of these cases after the first level of appeal, and frankly, that's too late for us. The reason is that the first level of appeal involves an evidentiary deadline, and you actually have to have every single piece of written information you ever want considered in the case in the record at your very first level of appeal, and you only have 60 days to put that together. So it's really important to get good guidance immediately at the very beginning. You do have 60 days from the receipt of the revocation letter to file your appeal, but only 30 days to file something called a corrective action plan. Corrective action plans are only available for revocations based on reason 1. That's that noncompliance reason. But if that is, even if noncompliance is only one of the reasons that's cited, and then there's another reason in the letter, oftentimes it can be useful to file the cap to get rid of the noncompliance revocation reason, and then you're left just addressing the other one if you have to go forward in the appeal. So it can be useful depending on the reasons that are stated in the letter. As we said earlier, if your revocation involves an excluded, suspended, or debarred person, you have a limited amount of time to get rid of that problem and or divest if it's an owner. Generally speaking, 30 days, and it's important that you get your healthcare counsel involved at that point to address the situation. There are some business things that you are probably going to have to consider if you get revoked. One of them is, you're going to have to reduce your Medicare census because you're not going to get paid for those people. And there's a process you have to go through to comply with both state and Medicare requirements to do that. It's likely you'll be able to keep your private pay business, depending on what kind of private pay business it is. If it's Medicaid or Medicare managed care, then that's a larger conversation to have with your healthcare counsel. You need to consider what you're going to do with your staff in the meantime. If you've got full-time employees and you're not going to have revenue to pay them, then it's only fair to consider what can you do, who can you retain, can you keep things going, or are you going to have to make some staffing changes? And it's really important to just understand that these situations, if you're revoked, don't often get solved quickly. You can be looking at 3, 6, 12 months while you go through the appeal process to address these things. And honestly, although Ashley and I have had tremendous success improving people's situations when a revocation happens, I would say it's way less than 50% of cases where the revocation actually gets reversed. Oftentimes what we're able to do is simply reduce the re-enrollment bar. So when you're revoked, there's a re-enrollment bar imposed of between 1 and 3 years, and that's how long you're going to have to stay out of the program. We've had a lot of success through the appeal process in getting those re-enrollment bars reduced. So it's just, there needs to be some realistic financial discussion and planning for how you're going to manage these scenarios. So I know we're at 1 o'clock, but we have a couple more slides where we were going to just cover the appeal process real quick. And Ashley, can you knock those out for us?
Absolutely. So Jennifer discussed for reason 1 cases for noncompliance, you can submit a corrective action plan for that. These are optional and they're due 30 days from the date of that revocation letter. You're not going to be able to fix a failure to report something, but you can address mistakes that were made. So maybe if a contractor, you did report something and the contractor failed to acknowledge that, and you can prove that you did, actually submit information, then you could fix things that way. You usually will get an answer on that in 30 to 60 days. But what's really important to know is that even if you're submitting a corrective action plan, your time clock for the reconsideration doesn't start based on the decision for the corrective action plan. It starts based on that same revocation letter. So if you've got a revocation letter that has a denial for a reason 1 case, you need to submit the corrective action plan and the reconsideration decision, or the reconsideration request, even though you're still waiting for a decision on the corrective action plan. They don't depend on one another. They're their own specific things, and you have to file each of them separately. So don't wait to file for the 60-day deadline for the reconsideration. As Jennifer said, the reconsideration is really, really important. We recommend that you engage counsel when you get that revocation letter, because this is your only opportunity to get evidence into the record. You can get it in at the ALJ level, but you have to show good cause. And not knowing that you needed to get it in is not good cause. It's a difficult thing to show. So it's really important that you get everything you ever want considered in the record at that first stage. You'll usually get an answer within 60 days, and then we can go ahead and go to the next stage. After reconsideration, if you don't get a favorable result, you're going to appeal to the Departmental Appeals Board. And this is going to be before an ALJ. There's a formal briefing process. And Jennifer and I have had a lot of success at this level working with counsel that's appointed to represent CMS and negotiating settlements with them at this level before we have to get into that bigger briefing process. If you do have to go to the briefing process, it is very formal summary judgment briefing where there are briefs submitted and responses submitted, and then you can request a hearing on the record where there is cross-examination of witnesses, but the judge can decline that, and then you're going to get a decision on that. There is a subsequent appeal to the Departmental Appeals Board, which again is a formal briefing process with an initial request for review, a response by CMS, and then a reply by the provider. And then you can always take these cases to federal court, to the federal district court where you're located in the country. But you have to go through all of these administrative appeals before you can get to the federal court process.
And with that, Ashley's going to catch her breath. She's talking so fast. We are happy to answer questions. I can stick around for a few minutes if there are any questions from the people who are listening.
Well, we're checking right now. For people who are asking about the slides, we will be sending them within 24 hours.
And you've got our contact information there, either email or phone. Ashley and I are more than happy to answer questions offline if you want to give either us a call or send us an email.
Yeah, absolutely. And I did want to mention, too, that I believe it's this evening, Jennifer, that you're going to be speaking for Provider Hour as
yes.
well, if anybody's interested. Do you want to talk a little bit about that really quick?
I would love to. So we've started a new evening program where some attorneys from our firm are going to talk about sort of current topics that are prevalent in the healthcare industry. And our provider hour for today is going to start at 6 o'clock Eastern Time, 5 o'clock Central Time, and we're going to talk about the Forest Park case. I don't know if anybody's been reading the news or following the case, but obviously the Forest Park Medical Center case recently resulted in a number of convictions or plea agreements for the principals that were involved in that. And we're going to talk a little bit about the background on the case and sort of where we see the enforcement activity, the direction we see the enforcement activity going as a result of that case, some of the new theories that the prosecutors were successful in pursuing in that case. So if you're interested, you can go to the lylesparker.com website, and I think there are instructions there for how you can join that.
Yep. And I think, okay, thank you, Jennifer. And apparently we don't have any questions. The only questions are about the slides, and they will be sent within 24 hours. So thank you, Ashley, and thank you, Jennifer, for the great webinar, and we'll see you next month.
Thank you, Jennifer. And if anybody does have any questions, please feel free to reach out to us.